Near Quickie, Fort Wayne Books v. Indiana is another landmark First Amendment case where the Supreme Court struck down pre-trial seizure of allegedly obscene material. In 1985, the city of Fort Wayne, Indiana, passed an ordinance that prohibited adult bookstores, movie theaters, and other similar establishments from being located within 1,000 feet of a residential area, church, park, or school. And you'd be amazed how much area that covers. It's something like 2/3 of the city. The state of Indiana seized materials from Fort Wayne Books, an adult bookstore, for, get this, RICO violations. Like they were an organized crime mob or something. The case was heard ex parte, in other words, without the bookstore having a chance to respond or even know it was happening. So Fort Wayne Books sued under the Fourth Amendment. But the state court said it was a valid seizure because the city had probable cause. The bookstore appealed, with 2 other bookstores joining in, saying that Fourth Amendment safeguards against unreasonable searches wasn't enough when the seized material was protected by the First Amendment. Byron White wrote for the majority, "It is incontestable that these proceedings were begun to put an end to the sale of obscenity at the 3 bookstores named in the complaint. And hence we are quite sure that the special rules applicable to removing First Amendment materials from circulation are relevant here. Our cases firmly hold that mere probable cause to believe a legal violation has transpired is not adequate to remove books or films from circulation." He also mentioned several precedents that say it doesn't matter how the law characterizes something as a RICO act or whatever. If it has an unconstitutional effect, then the seizure is unconstitutional. And you know your law is bad when the dissent is even more scathing. Stevens, joined by Brennan and Marshall, wrote, "It is true that a bare majority of the court has concluded the delivery of obscene messages to consenting adults may be prosecuted as a crime. The Indiana legislature has done far more than that. By injecting obscenity offenses into a statutory scheme designed to curtail an entirely different kind of antisocial conduct, it has not only enhanced criminal penalties, but also authorized wide-ranging civil sanctions against both protected and unprotected speech. Quite simply, the long-standing justification for suppressing obscene materials has been to prevent people from having immoral thoughts. The failure to do so, it is argued, threatens the moral fabric of our society. Limiting society's expression of that concern is the federal Constitution. The First Amendment presumptively protects communicative materials." Basically, they dissented because the majority didn't go far enough. Quote, "I would extend the court's holding to prohibit the seizure of these stores' inventories even after trial, based on nothing more than a pattern of obscenity misdemeanors. Many sexually explicit materials are little more than noxious appendages to a sprawling media industry. It is nevertheless true that a host of citizens desires them, that at best remote and indirect injury to third parties flows from them, and that purchasers have a constitutional right to possess them. I would not only invalidate the pre-trial seizures, but would also direct that the complaint be dismissed." He also made the point that any sale of such material to consenting adults, no matter how much other people might find it offensive, should be protected under the Constitution. We need more judges like that.